Hello everyone and welcome to Law Books Simplified. And as we all know that in this segments we are doing Code of Civil Procedure by C.K. Takwani, and we are going through every pages and every paragraphs and every lines of this book and trying to simplify it as much as possible. So today we're going to start from page number 6, chapter 1. So let's do it. Commencement. The Code of Civil Procedure 1908 came into force with effect from 1st January 1909, while the Amendment Act came into force with effect from 1st February 1977. It may be stated that the Code of Civil Procedure Amendment Bill 1974 was passed by Parliament on 23rd of August 1976. It received the assent of the President on 9th September 1976, and it became Act 104 of 1976 and came into force from 1st February 1977 except sections 12, 13 and 15. Section 12 and 50 came in force on 1st May 1977 and section 13 came in force on 1st July 1977. We'll go this section thoroughly. The Code of Civil Procedure Amendment Act 1999 received the assent of the President on 30th December 1999 and came into force on 1st July 2002. The Code of Civil Procedure Amendment Act 2002 received the assent of the President on 23rd May of 2002 and came into force of 1st July 2002. So let's move forward to consolidation and codification. The preamble of the code states that the object of the code is to consolidate and amend the laws relating to the procedure of civil courts and the courts of civil judicature. To consolidate means to collect all the laws relating to a particular subject and to bring it down to date in order that it may form a useful code applicable to the circumstances existing at the time when consolidating acts is enacted. So as it is said that this act is to govern, is to give the procedure to the civil laws, to the substantive civil laws of our land, but by which procedure these substantive laws will be exercised. The consolidation of this act says it. This CPC is the procedure in a laid down feature by which those substantive acts will accomplish themselves in reality. The very object of codifying a particular branch of law is that on the point specifically dealt with, the law should the henceforth be ascertained from languages used in that enactment and not from preceding act. The Code of Civil Procedure is a consolidated code as to procedure to be followed by civil courts, and as observed in Prem Lala Nahata versus Chandi Prasad Sikaria, the code consolidates and amends laws relating to the procedure of the courts of civil judicature. No doubt it also deals with substantive rights, but its essential object is to consolidate the law relating to civil procedure. So it just says that this code is for the consolidations of the procedures of courts of civil judicature. In a court of civil jurisdiction, how will those cases interact in those courts? How will we interpret and exercise the substantive laws in the code is written down in this procedural code. So moving forward to extent and applicability. The code extends to the whole India except Jammu and Kashmir, which is now exempted by the scrapping of Article 370, and the state of Nagaland and the tribunal areas, it is still accepted. And it also extends to the Amni Devi Island and East Godavari and Vishakhapatnam agencies in the state of Andhra Pradesh and in the Union of Territory of Lakshadweep. By the amendment of 1976, the application of the provisions of the code have been extended to scheduled areas too, and it has, however, been held that courts in such areas shall be guided by the spirit of the code and would not be bound by the letter of CPC. So let's move forward to the object of the code. The object of the code is to consolidate and amend the laws relating to procedure of courts of civil judicature. It is consolidated code collecting all the laws relating to the procedure to be adopted by civil courts. It is designed to facilitate justice and further its ends and is not a penal enactment for punishments and penalties. Not a thing designed by to trip up people. Too technical a construction of sections which leaves no room for reasonable elasticity and interpretation should therefore be guarded against, provided that justice is done to both sides. The provision of the code therefore should be constructed liberally, and technical objections should not be allowed to defeat substantial justice.
A hyper-technical view should be avoided by the court. So what it says is, this code, its object is to facilitate the courts of civil judicature with the civil laws, with the procedural laws which it needs to aid its substantive laws. And another thing to remember is this code does not enact any punishment or penalties, but it is open for with both of the ends for justice. And another thing is to remember that the provisions of this code should be constructed liberally, and technical objections should not be allowed to defeat substantial justice. And we have to keep it in mind that this code is not some ritual to be followed. Here it prescribes the way by which a substantial right will be affirmed to a person. So let's move forward. The provisions of this code have evolved as a manner of long years of experience emanating out of the common law of England. As per Supreme Court stated, a procedural law is always in aid of justice, not in contradiction or to depict every object which is sought to be achieved. A procedural law is always subservient to the substantive law. Nothing can be given by a procedural law what is not sought to be given by a substantive law, and nothing can be taken away by the procedural law what is given by the substantive law. What it actually says, procedural law is always dependent on the substantive law. Substantive law, to have the procedure for the substantive law, is called the adjective law. So here it should be kept in mind that this procedural law cannot give a person some right which the substantive law has not given him, but on the same stance, this right cannot take away a right from a person which a substantive law has taken it. And just for knowing, if there is a contradiction between substantive law and adjective law, the previous one will prevail every time. Anyways, let's move forward to scope. The code is not exhaustive. The code is exhaustive on matters specifically dealt with by it. However, it is not exhaustive on the points not specifically dealt with therein. The legislature is incapable of contemplating all the possible circumstances which may arise in future litigations, and consequently for providing procedure for them. With regard to those matters, the court has inherent power to act according to the principles of justice, equity, and good conscience. The code specifically provides that nothing in this code shall be deemed to limit or otherwise affect the inherent power of the court to make such order as may be necessary for the ends of justice or to prevent abuse of the process of the court. So what it says, it is exhaustive, which are specifically dealt by this code, but not exhaustive to the point where it is not dealt with. Like it is finally enacted on 2002, but there can be matters arised in 2025 where such particular matter was not dealt by this court. So in that case, this court will not be exhaustive. The courts will have some inherited power to deal with those cases which will arise in the future times. So let's move forward to the interpretation. Those substantive laws are very important. Value and importance of procedural laws cannot be underestimated. But the procedural law must be regarded as such. The function of adjective law is to facilitate justice and further its ends. The rules of procedure are intended to be handmade to the administration of justice, and they must therefore be constructed liberally and in manner as to render the enforcement of substantive rights effective. A hyper-technical view should not be adopted by the court in interpreting procedural laws. A party cannot be refused just relief merely because of some mistake, negligence, inadvertence, or infraction of the rules of the procedure. So here it says that.
So as we all know that the substantive law and the procedural laws are the two sides of a single coin. So in that view, the substantive laws are important and the procedurals are important as well. The aim of the procedural law is to facilitate the justice and further its ends. So the procedural laws, these enactments have to be made very liberally. Like any hypertechnical view should be avoided. For instance, no suits, pleadings, or any type of cases should not be unheard or disposed of only because of mere technical grounds. We have to keep it in mind that these procedures are not to be followed as rituals, but they are to be followed accordingly with the substantive laws. So moving on, rules of pleadings are intended as aids for a fair trial and for reaching a just decision. An action at law should not be equated to a game of chess. Provisions of laws are not to be made a formulate to be observed as rituals. Beneath the words of a provision of law, generally speaking, there lies a juristic principle. It is the duty of the court to ascertain that principle and implement it. Our laws of procedure are based on the principle that as far as possible, no proceeding in court of law should be allowed to depend on mere technicalities. The provisions of Code of Civil Procedure therefore must be interpreted in a manner as to subserve and advance the cause of justice rather than to defeat it. As I have just said, that these are not to be followed as rituals, but these are to further the ends of justice. So these procedures and these laws, they should be made liberally as far as possible, and no law should allowed to be defeated on mere technicalities. So moving on, there is a famous case law, Punjab versus Shamal Murari, wherein, speaking of the court, Krishna Iyer Justice observed, "We must always remember that procedural law is not to be tyrant but a servant, not an obstruction but an aid to justice. It has been wisely observed that procedural prescriptions are the handmaid and not the mistress, a lubricant, not a resistant to the administration of justice. Where non-compliance through procedural will through hard fan hearing the prejudice doing of justice to parties, the rule is mandatory, but, grammar apart, if breach can be corrected without injury to a just disposal of the case, we should not enthrone a regularity requirement into a dominant desideratum. After all, courts are to do justice, not to wreak it, and product of technicalities."
So moving on to the scheme of the code. The code can be divided into two parts. The body of the code containing 158 sections and first schedule containing 51 orders and rules. The sections deal with the provisions of substantive nature, laying down the general principles of jurisdiction, while the first schedule relates to the procedure of method, manner and mode in which the jurisdiction may be exercised. The body of the code containing the sections fundamental and cannot be amended except by the legislature. The first schedule of the code containing orders and rules, on the other hand, can be amended by high courts.
First one is the body of the code that contains 158 sections, and the second part is the schedule, the first schedule, which contains 51 orders and rules within them. So these sections, they are fundamental in nature and they can be only amended by the legislature, but the schedule on the other hand, that can be amended by the high courts. Looking to the scheme of the code as a whole, it becomes abundantly clear that the amendments made by the high courts in the rules contained in the first schedule also become part of the code for all purposes. As if enacted in this code, the sections and the rules therefore must be read together and harmoniously constructed, but if the rules are inconsistent with the sections, the latter will prevail. So here it says that these sections and the schedule, these orders, rules, they must be read together, interpreted together, harmoniously constructed. But if there is a contradiction between these rules, orders and these sections, if they are overlapping each other, if there is a question of law overlapping each other, then the sections will prevail, not the orders. So that's all for this video, and on the next video we will do retrospective operations and the code at the glance, and we will conclude the first chapter. So please do subscribe, and if you have any problems, please write on the comment section. I'll try to solve them as soon as possible. Thank you. Have a good day.